আপনাদের সকলকে আবারও আমন্ত্রণ জানাচ্ছি আজকের এই ক্রিমিনাল ল বিষয়ক আইনি অনুষ্ঠান ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমি আজাম কো সলিসিটার্স এর প্রিন্সিপাল সলিসিটর শাফিউল আজম এবং আমার সাথে আছেন দীর্ঘ 20 বছরেরও অধিক অভিজ্ঞতা সম্পন্ন ক্রিমিনাল লয়ের স্পেশালিস্ট ব্যারিস্টার আমার কলিগ ব্যারিস্টার আমিও ভলেন ওয়াইডার। আমরা যে টপিকের উপর বলছি যে বেশি বেশি কেস ক্রাউন কোর্টে যাচ্ছে সেক্সুয়াল অ্যাসল্ট এবং রেপের জন্য এবং দীর্ঘমেয়াদী জেল সাজা হচ্ছে। প্রায় 1/3 3 ভাগের 1 ভাগ ক্রাউন কোর্টের কেসগুলো এই সেক্সুয়াল অফেন্সের কেস এবং শুধু দীর্ঘমেয়াদী প্রিজন সেন্টেন্স না, 10, 20, 25 আরো বেশি ওর পরেও বিভিন্ন অর্ডার গুলো কোর্ট করে। সেগুলো হচ্ছে একটা হচ্ছে সেক্সুয়াল হার্ম প্রিভেনশন অর্ডার, যে আপনার উপরে বিভিন্ন শর্ত আরোপ করবে, বিভিন্ন দেশে আপনি যেতে পারবেন না এবং আপনাকে সেক্স অফেন্ডার্স রেজিস্টারের মধ্যে রাখা হবে। অনেক সময় দেখা যায় ইনডেফিনিটলি, অনির্দিষ্ট কালের জন্য। আমিও you could not finish this one, the how you can challenge, vary or discharge the sexual harm prevention order.
Right, I think I've just begun by going through some of the things that would apply to a sexual harm prevention order and restrictions and conditions, and really those matters which would be the subject, or potentially the subject of challenge. I mean, the bottom line is you have the right to appeal against your sexual harm prevention order, or to apply to vary it. If you receive the order upon sentencing in the magistrate's court, you make your application to the Crown Court, and if you were originally sentenced in the Crown Court, then your application should be to the Court of Appeal. Now, there are no specific requirements or criteria that the court must consider in such applications, but recent cases suggest that if you're applying to discharge your order entirely, you must demonstrate a change in circumstances. And if you wish to appeal, vary or discharge your order, in my opinion, it's best to seek legal advice. You may be able to get legal aid, but it's likely to be very difficult.
Yeah. What happens if someone breaches the sexual harm prevention order?
Well, if you fail to comply with any of the conditions of your sexual harm prevention order, then you may end up with a criminal conviction, and the sentence for said breach would be anything up to 5 years imprisonment.
And do they need to disclose that they are on the sexual harm prevention order?
Yeah, if you've been given a sexual harm prevention order as a result of accepting a police caution or upon conviction at court, that will form part of your criminal record and will be disclosed on criminal record checks, of course. However, under the Rehabilitation of Offenders Act, a sexual harm prevention order becomes spent at the end of the order. So while your conviction is unspent, you must disclose it to any employer, education institution, or insurance provider that asks you for a criminal record declaration. You need not declare it if you are not asked, unless the police or your probation officer require you to declare it. So once your conviction is spent, you'll not need to declare it when applying for insurance, and you'll not need to declare it when applying for most jobs and most courses, although of course there are some exceptions, and certainly jobs relating to children would be one of them.
দর্শক, এই সেক্সুয়াল অফেন্সেস এই আইনগুলো ইংল্যান্ড, ওয়েলস, নর্দার্ন আয়ারল্যান্ড এবং স্কটল্যান্ডের মধ্যে এই আইনগুলো এত কঠোর এত ড্রাকোনিয়ান এবং এত জটিল, এগুলো আপনার অভিজ্ঞ দক্ষ সলিসিটর না হলে আপনি ডিজায়ার্ড আউটকাম আসবে না। আপনার একজন এক্সপার্ট ব্যারিস্টার এনগেজ করতে হবে, যেটা আমি সব সময় করি। যে আমার কলিগ ব্যারিস্টার, আমিও ভলেন ওয়েডারের মতো, সে দীর্ঘ অনেক বছরের অভিজ্ঞতা সম্পন্ন একজন ক্রিমিনাল লয়ার স্পেশালিস্ট ব্যারিস্টার এনগেজ করতে হবে। যেটা আমি অনেকগুলো করেছি, দুই একটা না, মানে এটা অসংখ্য কেস, সেক্সুয়াল অফেন্সের কেস, আমি রেপ কেস, সেক্সুয়াল অ্যাসল্টের কেস আমি করেছি। এবং প্রত্যেকটা কেসের জন্য আমি যেটা করি, প্রথম ধাপে একজন উপযুক্ত দক্ষ অভিজ্ঞতা সম্পন্ন আপনার ব্যারিস্টার এনগেজ করি এবং চেষ্টা করি আমরা যতটুকু সম্ভব একটা বেস্ট পসিবল আউটকাম আনার জন্য। সব সময় তার অ্যাকুইটাল তো সম্ভব না, অ্যাকুইটেড না হলেও, খালাস না হলেও আমরা চেষ্টা করি কিভাবে একটা মিনিমাম সেন্টেন্সের মধ্যে তাকে রাখা যায়, কিভাবে এই সমস্ত বিভিন্ন অর্ডারগুলোকে মিনিমাইজ করা যায়। আমরা সব সময় সেই চেষ্টা আমি করি। আমরা বলেছি সেক্স অফেন্ডার্স রেজিস্টারের ব্যাপারে, আমরা বলেছি সেক্সুয়াল হার্ম প্রিভেনশন অর্ডারের উপরে। I will ask now, Amio, what is the sexual risk order?
So that is essentially something that replaced the risk of sexual harm orders in March of 2015, following the implementation of the Antisocial Behaviour, Crime and Policing Act of 2014. You don't have to have been cautioned or convicted of an offence to be made subject to a sexual risk order, but you may be given one if you've committed an act of a sexual nature and the police consider that you may pose a risk of harm.
What are the conditions of these orders?
So a sexual risk order will prevent you from doing whatever is prescribed in the order. The conditions must be necessary to protect the public in the UK or children or vulnerable adults abroad from harm. You'll not be placed on the sex offenders register, but you will be required to notify the police of your name and address and notify them of any changes to those details. And it will apply for a minimum period of 2 years unless the police decide to end it beforehand. If it contains a foreign travel restriction, that will apply for a minimum of 5 years.
Okay, and then talk about how to challenge, how to vary, how to discharge this sexual risk order.
It depends on the court. So you might, if you want to appeal against your sexual risk order, or apply to have any of the conditions varied, then you go to the relevant court. So if it's made in magistrates' court, either that court or any magistrates' court for the area in which you live in, where you would apply. When a youth court made the order, either that court or any youth court for the area in which you live. And again, if the youth court made the order but you're now aged over 18, it would be a magistrate's court for the area in which you live.
Yeah, and when someone breaches the sexual risk order, then what?
Well, again, it may result in a criminal conviction, and that's a maximum penalty of 5 years in prison.
5 years. দর্শক শুনছেন, আমার কলিগ ব্যারিস্টার আমিও ভলেন ওয়েডার বলছেন, এই ড্রাকোনিয়ান, এই কঠোর আইনগুলো, এই সেক্সুয়াল রিস্ক অর্ডার আপনি যদি ব্রিচ করেন, তাহলে আপনি আপ টু 5 ইয়ার পর্যন্ত 5 বছর পর্যন্ত আপনার জেল সাজা হতে পারে। এই আইনগুলো খুবই কঠোর, এই জন্য আমি বলছি এগুলো ড্রাকোনিয়ান। এই যে সেক্স অফেন্সের আইনগুলো, এগুলোতে আপনার মানে পুলিশ যেরকম খুব অভিজ্ঞ দক্ষ প্রসিকিউটর ব্যারিস্টারদেরকে এনগেজ করে, আমিও সবসময় চেষ্টা করি তাদের সাথে সমানে সমানে রাখার জন্য অথবা বেশি অভিজ্ঞতা সম্পন্ন। আমি চেষ্টা করি সবসময় একজন মানে দক্ষ অভিজ্ঞ এই সেক্সুয়াল অফেন্সের জন্য যারা ব্যারিস্টার তাদেরকে এনগেজ করতে। Now, what about the disclosure? Do they need to disclose it if someone is subject to the sexual disorder?
Well, a sexual risk order is a civil order, and it doesn't form part of your criminal record. Although the police will retain details of it on the police national computer. As such, there are no specific legal requirements for you to disclose that you are subject to a sexual risk order. This information would not be disclosed, for example, on a basic or standard criminal record certificate, but it may be included at the discretion of the Chief Constable on an enhanced disclosure and barring service DPS certificate, if the information is deemed to be relevant to the role for which you've applied. And again, if you wanted further information about the disclosure of police intelligence on enhanced DBS certificates, then that's really something that you would have to make further inquiries online for.
The law is very vast, Amio, in these things, in the sexual offences cases.
It is complicated, and that's certainly why I would recommend that nobody embarks upon it themselves and representing themselves. It requires somebody who has had considerable dealings with sexual offences in order to work through what is or would be for a litigant.
To get the best possible outcome.
Yeah, absolutely. And of course, and it's not just people who are working and adults. Sometimes it'll be people who are at college who are concerned about it.
Okay. Do they need to disclose their offence to the college when applying to the college?
Well, if your conviction is unspent under the terms of the Rehabilitation of Offenders Act, and the college is asking you for a criminal record declaration, you are legally obliged to declare your conviction in those circumstances if it's unspent. If it's spent, you will need not to declare it when applying for most college courses, although, as usual, there are some exceptions. For example, if you apply for a health and social care course that will require you to undertake placements, you're likely to be able to, or I should say, you're likely to be required to declare both spent and unspent convictions, which are not eligible to be filtered from DBS certificates. Sexual offences are not generally to be filtered.
What about that DBS? What is that DBS? Explain to the viewers, what does it mean by the DBS?
So that's the disclosure and barring service.
Yeah.
And it would be an enhanced check in essence, on your background for certain jobs. So that's really, I suppose, in terms of what it is. I should also say, while we're on the topic of college and whether you need to disclose it, if it's spent but you're still on the sex offenders register, so subject to notification requirements, you will not need to declare this when applying for most college courses. However, again, if the police public protection unit feel that there are any risks to the college that will need to be managed, they may require you to disclose, or they may make a decision themselves to disclose relevant information. So my recommendation, if you had any concerns about this, it's probably best to speak to your public protection officer and with them.
And And do they need to disclose it to the university when they are applying to the university course?
My understanding is that the UCAS application form asks all applicants to declare any unspent convictions. So if your conviction is unspent under the terms of the Rehabilitation of Offenders Act, you are legally obliged to declare your conviction when you make your application. If it's spent, you won't need to declare it when applying through UCAS. So as I say, if it's spent, you won't. But if you apply for certain courses, for example, a nursing degree, that will require you to complete placements, particularly in health or social care. And the universities will ask you for a further declaration of both spent and unspent convictions and cautions, which are not eligible to be filtered from DBS certificates. So those sexual offences are not eligible to be filtered. If your conviction is spent, but you're still on the sex offenders register and subject to notification requirements, you won't need to declare this when applying to UCAS. But if the police, the public protection unit, feel, again, there are any risks to the university that need to be managed, they may require you to disclose, or they may make the decision themselves to disclose that information. But again, as I said, it's probably best to speak to your public protection officer in those circumstances.
And UCAS is the university's central admission system, yeah, when they apply for...
It is. It's the standard, and it's the standard, they produce a standard form that has to be filled out when applying for university.
So let us talk on this more important one. Do they need to disclose their offences to their employers?
Well, it depends who you ask whether it's more important. But yeah, I certainly for people in jobs, they're going to be concerned about security for their employers. And that will depend, again, whether your offence is spent under the terms of the Rehabilitation of Offenders Act. Also going to depend on what job you're applying for. You know, if you're going to be working with children, or, for example, a job with police or something of that nature. It also depends on any restrictions that you are subject to because of your license or a sexual harm prevention order that might affect whether or not you have to disclose it.
And what is the employment advice for the people who have been convicted for sex offences?
Well, I suppose many employers still have a very risk-averse attitude towards recruiting people with criminal records, unfortunately. And these can be amplified for applicants having to declare convictions for sexual offences. So if you feel that you've made multiple applications to no avail, I suppose you can be assured that you're not alone, at least, and also be assured that there are employers out there who do employ people with sexual offending histories. There are some things, of course, that you can do to give yourself the best chance of securing work. Essentially, by understanding, I suppose, what you need to disclose.
Yeah. So someone should always think about what they should disclose, and they should think about it, and they should find out what they are required to disclose.
Yeah, I think it's a common myth that people convicted of sexual offences must always disclose their offences to employers. That's simply not true. If, as I say, your offence is spent under the Rehabilitation of Offenders Act and you're applying for a job that is covered by the Act, you will not need to declare your spent conviction. Obviously, it's stayed, as I say, related to certain jobs. And again, the length of time you may be under notification requirements may be longer. It's something you're going to have to consider. It may be longer than it takes for your offence to become spent. So if your offence is spent, you do not need to declare it when applying for jobs covered by the Rehabilitation of Offenders Act, just because you're still on the sex offenders register. But of course, the latter matter, the sex offenders register, may in itself cause practical problems for your job.
Yeah.
I'm not speculating as to what it will be, but that's really just a matter that you're going to have to consider yourself.
And there should be checking the recruitment policies, yeah?
Well, that's right. I mean, during the recruitment process, most employers do ask at some point for the disclosure of any unspent convictions as a minimum. And so while your conviction is unspent, you need to think of the best way in which you can make this disclosure. That's something that an agency I'm not particularly familiar with, but NAPRO can help you with. You need to ensure that you provide some context when making your disclosure, explaining the circumstances that led to your conviction, particularly highlighting, if you want to, any mitigating circumstances without letting your mitigation sound like an excuse. Obviously, you want to be still taking responsibility for your actions. And the most important part of your disclosure is explaining how you address the circumstances that led to your offending and how things have changed. The small declaration boxes on application forms do not usually, as people will know, provide the space that allows you to offer this information to the employer. So many simply ask that you provide details of the date, the offence and the sentence. Most of this information is of very little use to the employer when they're trying to make a decision about your suitability for a job. And so there are a number of ways in which you could respond to the declaration. You can simply tick yes and then qualify it with some level of reassurance. For example, I have only one conviction from 3 years ago. I'm happy to discuss it if selected for interview. You can draft a disclosure statement that you send in a separate envelope marked confidential and write on the form, please see enclosed statement. It's another thing you could do. You could draft a disclosure statement which you need not send in with your initial application, but on the form you can simply state, I have a disclosure statement which I'm happy to make available to the appropriate person. So there are, of course, pros and cons to each of the above.
Yeah. You are very well versed, you are very well familiar with this draconian law. Thank you very much. You've gone through in a very detailed way for all these serious sexual offenses orders. দর্শক আপনারা শুনছেন আমার কলিগ ব্যারিস্টার আমিও ভলেন ওয়াইডার, সে 20 বছরেরও অধিক অভিজ্ঞতা সম্পন্ন ক্রিমিনাল লয়ের স্পেশালিস্ট ব্যারিস্টার। সেই আপনার সেক্সুয়াল অফেন্ডার্স রেজিস্টার, সেক্সুয়াল হার্ম প্রিভেনশন, এগুলোর পরিণতি কি, এগুলোর কনসিকুয়েন্স কি, কন্ডিশনস কি, কিভাবে এই অর্ডারগুলোকে ভেরি করা যায়, কিভাবে চেঞ্জ করা যায়, পরিবর্তন করা যায়, কিভাবে এগুলোকে বাদ দেওয়া যায়, ডিসচার্জ করা যায়, সবগুলোর উপরে আউটলাইন করার চেষ্টা করেছে। আজকে সময় শেষ হয়ে গেছে। আজকের প্রোগ্রামটি আপনারা কাল সকাল 9:30 থেকে 11টা এনটিভিতে দেখতে পারবেন। তাছাড়া এনটিভি ইউরোপের ফেসবুক এবং ইউটিউবে লগ ইন করলেও আপনারা এই প্রোগ্রামের লিঙ্ক পাবেন। তাছাড়াও সলিসিটর শাফিউল আজম, আজাম এন্ড কো সলিসিটরস এই নামে গুগল সার্চ করেও আপনারা এই প্রোগ্রামের লিঙ্ক পাবেন। সবাই ভালো থাকুন, সুস্থ থাকুন এবং সকলের প্রতি আমার শুভকামনা থাকলো। আসসালামু আলাইকুম।